talk from our organizers here, Adam, Yufei, or Ofi. You can ask me a couple of questions if you need to. Thank you for sponsoring the venue once again, Security Office. Jordan, where are you? Thank you, sir. And today we have Saunders. This gentleman over here will be speaking about privacy and cybersecurity. A couple of things. If you need CP credits by the end of the event, feel free to come to one of us, and then we're gonna send some forms. And then, is anyone hiring here? We have one person hiring in the back, Pavan. So if anyone's to be used one. Okay, gotcha. So 2 people are hiring. Oh, and you pay as well. So just connect with them after the event. But after the event, we have an optional networking event as well at the night. So feel free to come and join us and hang out. Without further ado, I'm gonna let Ross introduce himself.
Okay. Toggle the clicker and the microphone. Everyone hear me? Okay. Cool. Are we on the slides? Right. So today I'm going to chat to everyone about privacy in dev and actually what we need to look out for there. Everyone familiar with the term privacy and things like the 4-letter words on GDPR and stuff like that? Yeah, fantastic. Cool. So we're going to go in. I'm going to give you a bit of a background about me. So I am. No, you put something on not disturb. Okay, here we go. Nerd with trust issues. That's me. And this comes from a bit of a background in the tech space and then going into privacy. So I started out my career in the call center side of things. I was on the call desk, the help desk, helping people with fixing their printers, things like that. Decided to move into network architecture, got into the network architecture side. Felt like there was a little bit of a ceiling in that space and decided to go into programming. Studied programming, loved it in college and absolutely despised it in practice. Might be because I was doing Java, I'm not sure. But then discovered what is now, I suppose, called DevOps. At the time, it was kind of pre-cloud. But getting that space between development and networking and how we get stuff deployed. During that time, moved into the management space. I was working with software as a service companies. And I spent most of my career when I was in corporate working for software as a service, translating legal requirements into what we can actually do technically. And speaking to the technical teams and trying to translate technical to legal and say, no, we can't do this, it's just wildly impractical. So that was my space for a long, long time. I studied privacy, did my designation in privacy protection in Europe, GDPR. I've done ethical hacking and I've done paralegal as well. Just a point on doing paralegal, none of this that I'm going to talk to you about is legal advice. Please consult legal if you're going to do anything from here. That's my little caveat. But I've spent the last 15 years or so working through privacy, helping software companies as to how to actually operationalize privacy within their teams, particularly in the dev space. Now, if I'm going into privacy, I want to go into a bit of background because privacy, and from the description of this event, privacy is often lumped in with security. And people will assume that, okay, well, we've got SOC 2 or we've got ISO 27001, privacy must be taken care of. So we don't think about it. Privacy is a lot broader than just that security space. Security forms part of privacy, but the two work together hand in hand. So I want to take you through a bit of a background around it so that everyone in the room has the fundamentals. Much like programming, if you understand the fundamentals of where privacy comes from, you can understand it no matter which law it goes into as well. So let's dive into a bit of a history lesson in privacy. Privacy has been around for a long time. It's not just from when GDPR was coming around. There have been privacy laws for a long time before that. It came around after World War II in terms of data. Now, countries needed to be able to transfer data between the different member states in the EU, what's now the EU, So they looked at how to protect the data, and the OECD came around and put together privacy principles. And most of our laws around privacy globally, maybe say for the US, which is the Wild West, are based on the OECD principles. And your GDPR, your PIPEDA here in Canada, PUPI in South Africa, LGPD in Brazil, all of them take from these principles. So let's go through them a little bit. I just want to check. Is that mouse cursor on your side or on my side? There we go. Cool. So, accountability principle. This is doing what you're saying you're going to do. So this is really up there in documentation. It's your governance side of things. We do what we say when it comes to data. We are accountable for it. We have policies. We have procedures. So first part of it. The next three here are kind of where we see our privacy policies come from. The purpose specification, use limitation, and collection limitation. Now, purpose specification is knowing what the purpose is that we're using data for. What are we going to do it for? Do we have a product that we're putting out there? We use data in order for that product to run. That's our purpose. It ties in next to the use limitation principle of saying, well, if we've specified that purpose, we don't use it for something else after we collect that data. So that's keeping it to a use limitation. Use limitation is also where we find things like consent and lawful basis of processing, and I consent to using my data, etc., etc. That's using the data legally. And then lastly, we get to collection limitation. When we've got the purpose and we know what we're doing with the data, and we've got our limitation and we're only using it for that, our collection limitation means we don't expand beyond that into more data points once we decide on our purpose. So it really keeps us sort of bundled in there, and that's where our privacy notices come from. Where you look at a website and there's a privacy notice at the bottom, it's generally touching on these three principles. Next up, we have data quality. This is having up-to-date data, and as we'll discuss in a few slides' time, how to actually update that data. But you need to have data that is of high quality, that's up to date, and regulators look for this. Was a great story when GDPR was coming around in the UK. There was an automotive manufacturer. They were wanting to comply with GDPR, which now brought in that, you have to opt into mailing lists instead of opting out of mailing lists. Let's mail our mailing list and make sure everyone wants to be on it. So they took their massive mailing list. They needed to sort it as to who was implied consent, who said yes, send me messages, and they took them the database offline and they went and carried on doing their analytics on it. And it took them a few weeks or a month or so to go through all that data, sort through the list, and then eventually they were like, okay, cool, we know who was implied consent. Let's send out an email blast so we're compliant and get everyone to actually opt into our mailing lists. In that period of time that they were offline working on that database, 1,000 or so people unsubscribed from their mailing list on the live list. They then fired off messages to these people. Do you want to still be on our list? They complained to a regulator saying, well, we've already asked to be on this list. So in trying to comply with GDPR, they got hit with a fine under the previous legislation in the UK and had to pay, I think, £18,000 for trying to comply. So this is the ridiculousness around having your data quality high. It's really important to have it up. So they could have checked that. Then our security comes in. So our SOC 2s, our ISO 27001, our safeguards, all of that, that comes in there. 1/8 on paper of privacy is security. It's not that your security covers everything that's in. Then the last two kind of tie into each other, openness and individual participation. Openness is saying what you're doing with data, don't be subversive, don't steal data, etc., etc. And participation, let people ask, what are you doing with my data? Why are you using it? Can I have a copy of it? Can you delete it? That kind of thing. These are all the principles. Now, these are privacy principles, but in my view, they're kind of doing good business principles. None of this is wild and out there as being something that's going to stop your business. Privacy is there, and nothing says, no, you may not do this. Maybe to Facebook and Meta and that side, but there are ways and means of doing what you need to do, and that's what I want to take us through. Now, with all of these principles, the different laws that are out there that we have to look out for is this massive table of mostly four-letter words. So in Canada, we're dealing with PIPEDA, we're dealing with Law 25 in Quebec, we're dealing with PIPA in BC and PIPA in Alberta. Those two are not the same law, even though they have the same four letters. It's different in each province. And where you have clients, where you have users, denotes which laws are going to cover you and what you have to comply with. So it starts becoming quite a maze, and thankfully there's generally normally a privacy office or a legal office that worries about the maze, but there are things that we need to do in development to support that. If we look at the USA, the main law that we always hear about is CCPA in California, CPRA now. There's many state-specific laws. They keep passing, striking down, bringing up, etc. It is the Wild West in the States when it comes to privacy. There is no federal law around it. But also from the USA, if anyone has users and clients in the USA, you need to worry about consumer watchdogs and predatory lawyers. So even though there might not be regulation that you have to comply with, there are lawyers and law firms that will look at websites, look at your privacy notices, things like that, log into your products if you have free products, see how everything works, and if you don't comply, they will slap you with a suit saying, hey, you don't comply, now here's money. Consumer watchdogs are also out there. They will look at your publicly available information, so what you put out in privacy notices. If they think it's a generic notice that doesn't match what your application does, things like that, they will publish that you're not doing this. And there are a number of watchdogs, a number of open source mechanisms that they use for this that you need to be aware of. EU and UK, we've got GDPR, which we're all fairly familiar with and have heard a lot of that. After Brexit, they split, and there's now a UK GDPR and an EU GDPR. And in the UK, there's the Data Protection Act, so that's a whole thing. Let legal worry about that. And then lastly, we've got our cookie notices on e-privacy and PECR. It's very hard to keep a straight face in a room when you're having a meeting about UK privacy and someone reads that out instead of just letters. It sounds very rude. Then we have BRICS, Brazil, Russia, India, China, South Africa. There are privacy laws there as well. Brazil's got LGPD, China's got PIPL, POPIA in South Africa, and Russia is just significant challenges in privacy, and most places will not let you transfer data. So we'll leave it at that. Now, onto cookies and consent, and where this starts filtering down into dev teams. Who has apps that they put out, like mobile apps? Okay, see a couple of hands, great. When we talk about cookie and consent legislation, generally we think of this is browsers, this is e-commerce, and it's that little bar that pops up at the bottom, accept all, reject, customize, etc., etc. What the laws refer to is this horrible and similar technologies. So if you are using browser cache, if you are using flash storage or anything like that on a device, it doesn't have to be a cookie that you're placing. The cookie laws actually apply to you. And it's things like notice, it's consent, and again, it comes to where your users are based. A lot of times here in Canada, federally, it's more a notice and it's a recommendation that, okay, yes, there are cookies in use. If we're in the EU, there is a whole split between strictly necessary, analytics, targeting, etc. I'll get into that in a moment. Quebec is just consent for everything. And you need to have like a granular control. If you want to see a good example on an app, download the Disney Plus app on your iOS or Apple device. I assume Android will be the same, but they've got a fantastic consent mechanism that shows up before you sign in. Often apps here won't show it because it's not required, but Disney does it really, really well. You can see a good example. Now, when we talk about the types of cookies or storage that we have, we've got first party and third party. First party is cookies that you set or items that you set in device storage. Third party is a third party storing them. So Google Analytics, Firebase, stuff like that. That will come in there for third party. And then we go into these three strictly necessary, analytics and performance, and targeting. Now, strictly necessary is generally the exemption to consent. So someone has to always consent to cookies on a website. Strictly necessary cookies no consent required, because they are required for the website to operate. It is things like if you have an e-commerce site, it is your cart persistence. So a cookie to keep the cart going when someone changes pages. It is your login persistence. If someone needs to log into a back end, it's keeping them signed in. That's what it's there for. Ironically, that would also be your cookie preferences. So you set the cookie to say whether your cookies are accepted or not, and that stays there. That's strictly necessary. Then we get into any other cookies that you put in. If there are cookies that don't break a site, don't break an app, if someone says no to, basically they have to be optional under GDPR. Quebec as well. Quebec sees everything as consent-driven. Quebec's a little hazy when it comes to cookies because they don't specifically require it. They just talk about profiling. So if you're creating any kind of profile of a user, Quebec says, yes, you need to have consent. What we're seeing in a lot of the legal texts is, and articles that are coming out is, look at these types of cookies and split them into essential and non-essential and kind of work on a European model until we start getting more guidance from them. And then lastly, targeting. This is the big nasties. This is your Facebooks, your Meta, your Pixel, things like that. Got to be aware of those when you're creating consent. And then a little bit more. We're going through the context here, and I'm blasting through it. I hope everyone's staying with me here. Everyone's still nodding. You're not nodding well, which is great. Data is not just sensitive. When we talk about our security sides of things, and we have internal data classification policies, things like that, we generally will refer to data as public, confidential, sensitive, restricted, and that's kind of where we leave it. That's great for a security platform or for ISO 27001 that doesn't really apply in privacy. Privacy has additional types of data that you need to be aware of. And as this data passes through systems, as it passes through our dev cycles, databases, we need to be aware of the different types and what our responsibilities are. Now, the first two, these are generally kind of lumped together: personally identifiable information and personal information. Personally identifiable, splitting hairs between the two here, that's kind of the information that you can obviously see this is personal. It's someone's name, it's someone's email address. I can identify them from that piece of data. Personally identifiable. Then we get personal information, which encompasses that. When we're dealing with privacy, generally your definition of personal information is anything that can be pulled into a profile of an individual. So not just email address, not just username, things like that. If you have a GUID that you're assigning to a user in the back end, if you've got logging that links an IP address to a user, all of that information becomes personal information under privacy. So these profiles suddenly get very, very big as to the kind of data we're looking at. So bear that in mind, and we'll bring that in a little bit. Then we have sensitive, and this is where a lot of the conflicts come in, where people are doing ISO and they have sensitive as a classification. Sensitive information under privacy law is either defined, like in GDPR, or it's contextual, like in PIPEDA here in Canada. So under GDPR, we have sensitive information, special personal information, being things like your health and sex life, your sexual orientation, your political party membership, your trade union membership, race and ethnic origin. All these things come in under defined categories under GDPR. And when you have that type of information in databases, etc., unless there's a law telling you you should have that, like an HR or labor law or something like that, you need additional consent to have that information legally. Under Canada's law, it's contextual. Any information can become sensitive in Canada. Think about to give you an example, think about a doorbell cam. So you've got a doorbell cam on your front door. It looks over at your neighbor's door, and that's recording when someone walks past or something like that. So your neighbor gets home on a day-to-day basis. They open the front door, they go in. That's not sensitive information. There's not any kind of abuse that's going to happen out of that. It's just information. say one day your neighbor arrives home, they're highly inebriated, they brought someone home with them, that's not their partner, they are stumbling up the stairs, and they go into their place. That suddenly becomes sensitive in Canada, because now there's all sorts of things that can come out of that data and be inferred from it. So your context of how you're using it, if it can cause embarrassment, if it can cause stress, if it can cause a material impact on someone's livelihood or something like that, that generally forms sensitive information in Canada, and you need additional consent for it. So something to be aware of when you're putting together data sets. This is also why I think data analysts and data scientists and privacy people often have fun discussions around how data can be used. Then we have health information. This is generally if you're working in healthcare, so PHIPAA in Ontario, HIPAA in the US. And then we have the fun one of public information. So information that's available publicly, let's grab it, let's scrape it, let's make ourselves a database, and we can use this information. Under privacy laws, you can't do that. Generally, what needs to happen there is if you've collected public information, you're going to use it for something, it's up to you to get hold of the people whose information is in that database, say you've collected it, this is how we're going to use it, do you want to opt out? So it becomes very important to be aware that you can't just scrape information. There's been tons of arguments about LinkedIn and scraping LinkedIn because, oh, that's public. It's behind registrations, that doesn't make it public, and things like that. So it's a wild, wild area here that you've got to be aware of. You can't just scrape. Thankfully, in the age of AI now, it's actually very easy to build up data sets in a short time frame. So I would recommend doing that as well. Okay. Everyone's still with me. I don't see anyone falling asleep, which is great. Now we go into the second half around how it affects development. So, anyone here familiar with OWASP-SAM? Okay, Software Assurance Maturity Model. The OWASP-SAM is a great way of looking at the security of your SDLC and looking at the maturity of that. It applies really well over to privacy as well. So what it is, it basically breaks down 5 functions within development, and then it has practice areas within each of those functions, and there are controls under each of those practice areas. This applies so well to privacy as well. So if we look at the first one, it's governance. Remember when I did the context, we had accountability. Governance comes in here. This is talking about having strategy, metrics, policies, education, etc. Next up, we have the design phase. So in the design phase, are we looking at threat assessments? What privacy requirements are there? Are we looking at privacy by design, PBD? How are we bringing this into the design phase? Implementation, we're looking at secure build, secure deployment. Those definitely stay the same. Your defect management, how you're managing defects. We look at the verification side of things, your architecture assessments, your requirements driven testing, how you run things through QA, your data flows, and then your operations. So things like incident management, environment management, operation management. So these are the spaces around development that we can apply this to privacy. And there are some very good things that we can put in each of these categories that I want you to take with you today, and that definitely come on the data side. So if we look under governance, like we said in accountability, the first thing is have standards and policies. And just to change that icon, rather have better policies, don't have crappy policies. Please have your policies match what you actually do. What we often see is you have what I call an SYA policy, a say your ass policy, and someone will get legal in. Legal will draw up the policy for every possible eventuality that could happen under the sun. So if that happens, someone can get fired and we can say, oh, well, this isn't the spot in the policy where you need to breach. That was great many, many years ago. When it comes to privacy, what happens with regulators is they will come in and see, like, do you have policies? Someone's complained about you, they'll contact, what are the policies in place? Cool, here's our policies. Next question is going to be, do your policies match your practices? So you need to be careful about it. The policies have to be good. They have to match what you actually do. One of the beautiful things about most privacy laws is they don't mandate, like, oh, you have to have these 16 things in your policies. They tell you these are the principles you have to adhere by, build your own policies. So if you are a small company, you can build great agile policies. If you're a bank, you're going to be held to a different standard. you should have really robust policies. So it really works together well with that, but you need to have documentation. Everyone loves documentation. Then we need to look at training, at least annually. Most privacy laws will require training at least annually. And this training does not necessarily have to be boring. Unfortunately, I mean, we've seen how much security training is out there. That's great. There's these micro trainings, micro learnings, things like that. They try and cover a lot of privacy, but often it is so generalized that it doesn't cover. Privacy training generally works most effectively when it's tailored to the company and what you're doing. It's tailored to your data, to your policies, things like that. And it can be done in various ways. You can have sessions like this where someone comes and speaks for a learning lunch or something like that. You can have, I do recorded videos for some of my clients. So every time someone's onboarded, they watch a video series and off they go. Other clients could be a series a month, etc. But you want to have privacy training done. You want to have it done to your policies. So when you're bringing on new team members, you bring on new folks into the teams, you want to train them on how you do things, how it relates to privacy. And then lastly, you want the ability to track metrics. This is again that accountability. So something that is going to be a theme through here is if you've got issue tracking systems, what I would highly recommend is add issue types for security and privacy. Because then you can actually track those issues and your debt in all of them. Because as much as you've got technical debt, you get privacy debt and security debt as well. We'll get into that in a minute. Next up on the design side, who here has done threat modeling? Okay, cool. There's a lot of hands going up. Anyone done privacy threat modeling? Oh, a couple of hands. Fantastic. Okay, so when we talk about privacy, we kind of see two sort of risk assessment spaces when we get to the design phase. One being DPIAs, data privacy impact assessments, which some people might be twitching in the room for those PIAs. If you're working in the public sector in Canada, generally you'd be mandated to do them. Private sector, it's highly recommended that you do them. Quebec, it's mandatory as well. Europe, it's mandatory for what you're doing. These are detailed risk assessments of what you do with data. How do you collect the data? How do you use it? What do you use it for? Who is it shared with? These take a long time to put in place. These are, you can have them done in like 2 months, but they can take up to 18 months. Some of the ones I've worked on have been 2-year slog to get these data protection impact assessments out. That's generally for big products that are already released. The flip side for design is the threat modeling side. It is such a great, quick way of getting risks up front for your systems. Under privacy, we've got two sort of main ones that I see used. One's Linden, L-I-N-D-U-N. And then we've got Plot for AI, privacy library of threats for artificial intelligence. Now, Plot for AI is built on Linden. Linden works on, it's an acronym for linking, identification, non-repudiation, and the rest escape me right now. But it gives you a whole lot of categories that you need to run through. And a lot of these threat assessments are available in a card deck. So what you do when you've got a new product or design that you're needing to do, you get all the stakeholders in the room, get business analysis in the room, get devs in the room, get product management in the room, and start working your way through the card deck. Top of the card asks you the questions about what your system's going to do. Is it a yes, no, maybe? If it's a yes, flip the card, and it tells you what your likely risks are going to be and what you need to consider. It is an incredibly quick way to identify risks in a rapid style for everyone in the room to see. You can document it, you can work with them, they can make their way into issues. It's great. Highly recommend looking at that. And it catches very, very cool things. I mentioned non-repudiation. That's a very interesting place between privacy threat assessment and security threat assessment. Security threat assessment, you want to know that someone is that person, absolutely without a doubt, that they did this in a log. Privacy, you want that plausible deniability side of things. Think about websites and password resets. So if you have a function that you're building to reset a password, someone goes there and maybe it's a site that can tell a lot about a person. Think of that sensitive information. Think back to Ashley Madison breaches and things like that. You've got a password reset form, like, oh, enter your email address, we'll send you a password reset link. Type in an email address, hit send. If that form says, oh, thank you, an email has been sent to your username to reset your password. You can be pretty sure that that someone is a user of the system. So even if you just put in email addresses, you can start telling, oh, that's a user because it gave me the affirmative that it's going to. Under privacy, you would want the link to rather say, if this is a user, we would send them an email address. So you can't tell from the wording. That's how simple some of these can be in terms of privacy, and that's what those cards highlight. So bear that in mind. Next up, your consent, your notices, your cookies. Like I said, take a look at how Disney does things on their app, Disney Plus. The first time you load it up, it'll give you I think it's almost overkill. It's a laundry list of what they do. You'll also be horrified if you go to the customize option and you see how much data that they take from you. But you need to have those in also for apps. If you are doing this kind of thing, you can do it yourself. You can build it in. You need to update it regularly. Every time new cookies are set, every time new device storage is used, you've got to look into it. There are products out there that handle this for you, that have built SDKs that are built into this. You can tie those into your marketing. You can build all your consent for the whole company together, and dev can use the different libraries for it. So if you're business to consumer, I highly recommend looking into that. It's a fantastic product out there as well called Catch that does a really good job about that. And then data subject feature requests, make what you will of the icon I've used for this. Data subjects are the individuals who data belongs to. So this is Joe Public. You need to respond to people. We spoke about that data subject participation in the privacy rights and the OECD principles. So this is where we have things like data access, data deletion, in Europe, data portability, where I want to move my data to another service provider. People have rights that they can put requests in. I say requests because rights aren't absolute. So you don't always have to respond to these, but they will take up a lot of your time. So when we look at the design phase, we want to look at how you can build your systems to be able to respond to these requests. So deletion and access are kind of the two big ones that you'll receive. Deletion is delete all data that belongs to me. Remember when we went through what is personal information? That can get very big. You're looking at all these IDs, things like that. Deletion also isn't necessarily nuke the data. It could be de-identifying. So de-identification done properly is seen as a deletion. So you can do that. Because often if you just do a blanket delete, you're going to break the database, you can break relationships, things like that. So you can anonymize the data. But that deletion is the easy one. It's access that is the absolute beast. And you don't realize how big this is. I worked with a company, and I'm going to take this from an employee standpoint because it just illustrates how much data gets developed. A former employee of a company got very grumpy after leaving and put in an access request for all information that the company had on them. This was in Europe. Please give me everything related to my time employed at the company. This was a 2.5-year period. That's fine. You think, oh, there's emails, there's perhaps what they worked on, stuff in their shared folders, their OneDrive, etc. Yes, it's all the emails. It cannot be given to them in something that they have to pay for. So you can't export a PST. You've got to put all the mails out in PDFs. Over a 2-year period, the product manager gets a lot of emails. So that gets huge. You then can't give them information that has other people's information in it. So now you've got to de-identify, go through every record. Is there someone else's information in here? Redact it. Can't do that. Then we get to Teams and Slack and all the messages that have been sent. We get to the company socials, the photographs that have been taken. All of this becomes personal information. This put the department down for, I think, over 45 days, the entire HR department and 2 IT leads trying to get all the information. It was wild. Eventually, it was pushed back as being frivolous and malicious, and there was regulators involved, etc., etc. But that gives you an idea of how complex these get and how quickly. One of the things I've seen as well often is in our privacy notices, we don't say this is how you exercise your rights. And most companies will be like, well, we don't get any data subject requests. That's because you haven't advertised that this is how people can put their rights in. Every time we've changed the privacy notice and said, okay, this is how you contact us to remove your information, that flow upticks beautifully. And if you don't respond to these things, the regulators can come and inspect you. Oh, you're not handling DSARs right. Let's look at the rest of your practices and what you do. And suddenly it's no as well. So you've got to build this kind of thing in. And if you can build this in the design phase, this is how we handle deletion. This is how we handle access. It makes your life so much easier to do. Next up, implementation. So I mentioned having privacy issue types in your tracking systems. You want to add issue types for privacy that you discover as you're discovering them, and you want to be able to track them and respond to them as though you would on a roadmap. Because if we think of security, we think of privacy, I will go out on a limb here and say security is easier to band-aid and patch and do something quick that fixes the problem. Security, there are tools out there, there are libraries, we can block ports, we can do all sorts of cool stuff that changes the game very quickly. Privacy, you're in for the long haul. Changing a business process or a function that is collecting data incorrectly in a live system, that takes time. So if you're putting in a program from scratch, you're looking at 18 months turnaround time, where a lot can go wrong in that space. So you want to start tracking the types of issues and seeing what's critical, what you can address, what you can't, what you're going to put on the back burner. It needs to be addressed in that way. Don't have privacy sort of disappear into the flow. Your secure deployment, keep calm, keep doing that. If you've got secure deployments in place, just keep doing that. That ties into your privacy side of things. All the documentation you have for that, the processes, that ties into the safeguards. In privacy, we have something called TOMs, which come from the European side of things, technical and organizational measures. Your deployment side of things are your technical measures that you put in. That's your processes as well, those organizational measures. And your sales teams, when they go out to sell the products, need to sign off those TOMs and what you've got in place, and companies will request it. So having that documented, being able to put that forward helps the sales teams as well. And then please keep devs out of prod. Role-based access control at the very least, please don't do it. There are a lot of ways that this can go horribly bad. We see it all the time. It also adds to your footprint of what can go wrong. If a regulator comes and looks and sees, oh, your production is accessible by a whole swath of teams, they're going to say you're not doing very good controls there. And yes, in Canada, we don't aside from Quebec, we don't have financial penalties in here. We do have very publicly posted reports from the regulator. So if you go to the Privacy Commissioner, if you go to the Privacy Commissioner's website and you go look at reports, it'll have the initial reports. So, oh, someone complained about this company. We went in and investigated. This is what we found. This was the entire report. This is what we told them to do. Publicly available for all the investigations that they do. When they come and inspect that you did what you said you were going to do or not, that goes up there too. So it's very public information. It can be very damning if you do the wrong thing. And then we have verification side. So testing. One, build your privacy test cases. And this goes back to the design phase as well. If you're building functions around privacy, build test cases as to how QA can test them, how people can test them, how you can automate the testing for privacy. This ties into things like, do the DSAR requests actually work? We built a function to delete people's information. How is that working? Is it removing all the correct information? Things like that. There are a lot of test cases you can build, and there are automated test tools that have privacy suites as well, where you can make sure that your development side is working. Next, data flow validation. So this comes back to those purpose specifications and collection limitations. If you start noticing new data in a database, that's a warning bell. And that's where people need to kind of raise their hands. And when I work with companies, we rely on dev to raise their hands if we don't have automated tools in place. Because new information can suddenly make its way into a database very quickly. I've seen passport information, I've seen SIN numbers suddenly make it into a feature that doesn't need SIN numbers. And that's where we need to raise kind of alarm bells and have standards as to what can and can't be collected, because it can hit us later down. And then please, no production data in test. This relates to the whole no devs in prod. One of the things that I dealt with a while back, which was a wild situation to walk into, it was a client I started working at. They had a bunch of clients that had been around for many, many years. One of their clients left. They got grumpy, disgruntled, left. What happened was they then took the database, it was a really good piece of work that they'd done on the database, and they really liked it. They moved it into testing. They did a bunch of work there. They de-identified it in that they just replaced some names. And they used that. Then people forgot where that data came from. It made its way into sales databases. It made its way into demo systems. And there it stayed. Yes, it was de-identified from names, but that was it. 5 or 6 years later, this is when I started with them, went out to a client, or potential client, to go talk to them, displayed this test data. It was the client that had previously left for being disgruntled. They looked at the data, took one look at the data, and were like, hang on a second, this looks a lot like our data. And it turned out it was their data. This was not privacy information, it was just confidential information, but that went into, from a sales meeting, went into a legal meeting very, very quickly. So be very cautious of that. Don't bring production data into test. If you do have controls around it, sometimes we do need to troubleshoot on live data. Have processes in place that stop that data staying there, that clears it out, etc. And then our operations space. So cross-border must be considered. And we can often decide to use new tools, new functions, build something new, and oh, this is a great little library that we can use. This is a great piece of software that's been sold to us. Suddenly data transfers from Canada over into the States, or it transfers to India, or it transfers to Colombia, or something like that. Whenever data crosses a border, you need to consider it. And if we add functions in development, that needs to be raised with whoever is handling the compliance, be it the CTO or CFO that we see in a lot of companies, CEOs. Raise it with them that there's a new transfer across the border. If you're dealing with European citizens or residents, even not even citizens, and you cross their data over to a border where the country is not seen as adequate in Europe's eyes, Canada is seen as adequate, US is not. So if you store something in the US, there's a whole lot more paperwork that your privacy compliance people have to do and to sign off. And there's probably contracts that sales are signing that have requirements around cross-border for dev that devs never see. So there needs to be a conversation between the dev team and the sales if you're selling into business to business or business to consumer as to where data is being kept, because you will see loads of requirements for dev in a contract that dev never sees. So be aware of that. Address privacy debt, please. Like I said, privacy debt adds up. Privacy also explodes spectacularly when something goes wrong. So little breaches often become big breaches very, very quickly. Be aware of that. And then build in time for those DSARs. I told you how long it takes with that example around an ex-employee. When I've worked with software companies and their business to consumer, we've often seen these requests start coming in on a steady flow. 2 this month, 4 the next month, 16 the next month, 30 the next month. And people want access to their data. They want deletion from their data. Deletion is the most common one we see. But when you're starting to get 35 requests a month, it's not viable yet to get an automated system for $30,000 a year, but we still need to respond to these. So it takes dev time and people to write scripts to go and find all the data, de-identify it, get access to it, export it, get CSVs, etc., etc., etc. So build in time for that in your operations. I say B2C here because there's a different process that happens in B2B2C when it comes to personal information with these data subject requests. Your business that has the relationship with the client that is telling what data we need and why we're collecting it, etc., they are responsible for the data requests. If you are a service provider or a development house that is providing software to a company to sell to their clients, and you're working on their behalf and they've hired you as a processor, you should not be acting on these subject requests. If someone asks you to delete, you should not be doing that. because that could be a breach of your contract with the client. And it's also in Europe, that could be a breach of GDPR as well. You have to hand that back to the responsible party or the controller for the data. So be aware that don't delete information if you are business to business and you get a request from one of their clients. You should never be deleting that information. You could be putting your client at risk by doing that as well. So keep that in mind. You should always rely on them for that. And that is also in those sales contracts, I can pretty much guarantee. Right. So that takes us back to here. I hope I've given you guys like a few action points that you can take from that. Again, this is OWASP SAM. It's been modified for this one. And I would like to thank you for that. And if you have any questions, into that. Also, sorry, if you do want to find out more about this stuff, I do have a whole bunch of material as well. Newsletters, blogs, things like that. You can subscribe. There's an assessment for dev teams as well if you want to see where you're standing. But yeah, thanks very much.
You keep mentioning the different privacy laws that are in Quebec as opposed to the rest of Canada. What is in scope for that? Is it if somebody, like a credit law person, is a part of the application or what?
Yeah, so in Quebec and with the Quebec law, any residents within Quebec, that law applies to them. So if you have servers here in Toronto and you have users that are based in Quebec, Quebec's law 25 will apply. And Quebec, the law 25 would even have that if you're transferring that data out and hosting it in Ontario, you need to do a transfer impact assessment on that data. Yes, you can do the transfer. Thankfully, Quebec is a lot lighter than GDPR, so you don't have to do this TIA that you would for GDPR that is massive. You can do like a little 15-minute assessment because it's still within Canada, the law is still
Oh, okay. It's not massive then.
They can get massive. It depends on the data that you're going to have. So if you're processing wildly sensitive data and you're a health tech company, right, then chances are your TIA is going to be a lot bigger. If you're just taking usernames, you're going to have far less risk. So take a risk approach, and that will inform how big and detailed that TIA is.
Thanks.
For the data crossing a border, it sounds impossible to me in this day and age with all the software as a service enmeshment. So, I mean, if you have strong vendor process for you on how border crossings happen, but then these vendors might have arbitrarily large chain of dependencies of their border crossing. So I feel this is impossible today.
Yeah, it is difficult. It's not impossible. So I think one of the things that we jump to, and this is, everyone have time for another keynote on sovereignty and residency. So when we talk about residency and sovereignty, so residency is where the data is sitting. Is it resident in Canada? Is it resident in the US? Sovereignty is which laws are in control of that data. Under GDPR, there are a whole bunch of things around processors, sub-processors, and things like that. So if you're complying with GDPR, there is a lot of paperwork in that chain. But chances are, if you're working with these big guys, like AWS, Microsoft, GCP, and stuff like that, they already have a lot of that material available. So if you go look at the different privacy centers for them, they would say, like, these are what they're doing with all their providers, etc. What gets difficult is smaller providers as well that don't necessarily track this, or providers that aren't in countries that have ever had to do this before. And that's where there's a duty of care that you need to assess your vendors. It is not to say that you cannot send data. We often jump to the conclusion that, and we see it in all the newsletters and things like that, like, oh, data's got to be sovereign and it's got to stay in border, especially with the US Cloud Act, because now the US government can access everything. Yes, they can go through the whole processes and things like that. The Cloud Act paves the way that they can get data from their subsidiaries in other countries, which is a different side of things. But there's still due process. There's still controls in place. If you look at the likes of Microsoft, Microsoft has a whole transparency report as to how many times they respond to those. they push back on governments, and we use all of those as your technical and organizational features. So the more transfers you have, the more you can protect it early in the chain. So you can give less data, or you can pseudonymize data, so partially anonymize it. That, okay, now it's not personal data that goes there. This is what we see with sovereignty with Microsoft 365, where you can't transfer health data out of BC or something. So, okay, you can use 365, but don't put identified data. There's a lot of assessment. It's not impossible, it's big.
In the B2B2C scenario, assuming you are the business serving the consumer, but you have an upstream business providing a service that stores PII, so on, and you get a request saying, delete all of my data. I don't have the data. My upstream vendor has the data. How responsible would my company be in making sure that upstream company did delete the data?
Yeah, so that's kind of the accountability and responsibility argument. So your company would be accountable for that, particularly if you're looking under GDPR, which is kind of the gold standard that a lot of laws are working on. So you, as the company that's making the decisions on why we collect the data, etc., you're accountable. But you would generally have a data processing agreement with your vendor that if you had to receive those, they must assist you out, and they would need to delete it. It comes to those purpose specification and things like that as well. Your vendors can't go and use the data that you store with them for other purposes unless there's an agreement for that with everyone in the chain. So there should be agreements, at least contractual, through everyone as to, yeah, you guys are hosting our data. If we give you a deletion request, you should remove it. But that chain has to be completed. That's deletion, access, generally, and they should be assisted. Does that help?
Yeah.
Any other questions?
Just terrified stone silence.
Right.
In your experience, let's say you have a small company, what is the turning point where they decide they have to go through something like the OWASP SAMM and improve their privacy posture?
The biggest turning point for doing an assessment like that and all that is normally when clients requesting it. So you might be signing up a big corporate client, and that becomes a requirement. They hit you with an assessment, what's your privacy programs, etc., and then you go scramble to respond to it. Some companies do it because they know they need to handle privacy, so they just start it early and it's baked in, which is honestly the best way of doing it. But it's generally a contractual requirement, or you've been breached, and then okay, now we need to fix this. So that's where a lot of it comes in. Okay.
Thank you, Ross. Thank you, Secure Compass, for sponsoring the venue once again, and all the organizers. Just a couple of announcements that I would like to make. So OWASP Toronto is trying to transition away from meetup.com, but future announcements will follow. Just keep a lookout of your Meetup accounts, and we're gonna try to figure something out. And our events for the future is gonna be hosted on a different platform, and hopefully we can get that sorted out. We are going to meet at the Pint. So a few of you who would like to kind of hang around and just kind of hang out and network a little bit more, we're gonna go there straight across in about 30 minutes. Yes, in about 30 minutes. And then if you don't mind also helping us putting the chairs up as well after this event, that would be really appreciated. Again, I think there are 3 people who are hiring today, so go ahead and speak to them. I think Spencer, Yukfei, and Pavan, so at the back there. And you, what's your name?
Kyle.
And Kyle. So 4 people are hiring. So if you guys are looking for a job, feel free to reach out to them. And anything else? I think that's it. Thanks, guys. Appreciate it.
Thanks for speaking.
Oh yeah.
Please.